Friends, a burning issue in GST since the very beginning of GST in 2017 has been that whether the recipients are required to reverse their input tax credit due to mismatch with 2A or due to the fact that suppliers have not filed their GSTR 1 or GSTR 3B. Friends, section 16 subsection 2 clause C states that input tax credit would be available to a recipient only if the tax related to the transaction has been received by the government. This 16(2)(c) has been a point of contention from the end of the taxpayers since the very beginning. However, it has been held in various cases and it does not require a High Court's decision also. It is embedded in the Act only that this reversal of input tax credit due to non-compliance of the suppliers cannot be automatic. Friends, if you see section 42, that is the first legal defense and our legal submissions in this matter, that section 42 subsection 3 provides that in case an input tax credit is found to be in excess when it is matched with 2A, then both the suppliers as well as the recipients would be intimated, and only if the supplier does not rectify its GSTR 1 or 3B, only then input tax credit of the recipients would be required to be reversed. The press release dated 4th of May 2018 also provides that there should be no automatic reversal of input tax credit at the end of the recipient if the supplier does any non-compliance. Input tax credit would be reversed only if the supplier is not traceable or the supplier has closed down its business or the supplier has gone bankrupt. Friends, many a times we see that the supplier's registration is cancelled by the department due to certain non-compliances, and the input tax credit of all the recipients since the very beginning of GST, that is disallowed by the GST department. This, I would say, should not be automatic, and recently the High Court of Madras has held in the case of DY Bethel Enterprises that the input tax credit reversal cannot be automatic. In the instant case, there was one Mr. Charles and his wife Shanti who supplied goods or services and issued invoices, received the GST payment from the recipients, and their assessment was also done by the department. They were traceable, but due to mismatch, the recipients was asked to reverse their input tax credit. The Honorable Madras High Court has very clearly held in the instant case that Charles and his wife Shanti should be first be summoned by the GST department, and they should be the ones who should be asked to pay the GST in the instant transaction, and no automatic reversal of the input tax credit should be done. The matter was remanded back with a direction to the GST authorities to summon these Charles and his wife Shanti. Friends, a similar position was held or taken by the Apex Court in the case of Arise India Limited and others in the matter of Delhi VAT, where it upheld the judgment of the Delhi High Court. It laid down two very important doctrines, as was also held by other High Court in Punjab and Haryana in the case of Gherulal Balchand versus State of Haryana. In the case of Arise India, the Apex Court laid down one important doctrine of impossible performance. It laid down that the recipients who are bona fide cannot be asked to run after the suppliers and to make them follow the act and file their returns and pay their taxes. Secondly, a bona fide recipient should always be distinct from a guilty recipient, right? So if the recipient is found to be bona fide, he cannot be treated at par with a guilty recipient. If it is done, it would be against Article 14 of the Constitution of India. A similar position was held in the earlier VAT regime by the Madras High Court also in the case of Vinayaga agencies, where a similar position was held that a bona fide recipient cannot be made to suffer due to non-compliances by a guilty supplier. So friends, the judgments and the position taken by the courts, that is slowly becoming very clear as per the GST Acts. So in case if such a situation arises, I am sure in many of the companies a similar litigation would be looming large. These would be the legal defenses or submissions, and if the companies can identify their suppliers, then I would say it is a very strong case, as has been held by D.Y. Bethel Enterprises by the Madras High Court in that case. Thank you very much.